Next case here. Next question. Can the USCIS transfer a pending affirmative asylum case to immigration court without deciding it first? And was ICE allowed to issue an NTA and arrest me while my I-589 was still pending? This is a whole new development, and I want you to listen to me very clearly, James. When ICE issued that NTA and place you in or places an applicant in removal proceedings, immigration may have closed or transferred the affirmative asylum case because the immigration court is now the one that has jurisdiction to decide your asylum, because once your case is in court, it's immigration judge that has the jurisdiction to decide your case. So that means your I-589 is not gone. It now becomes a defensive asylum case before the immigration judge. The immigration can confirm when the proceedings are pending. It can send the I-589 to immigration court for jurisdiction. In other words, if you are in court and you file asylum with immigration, they don't really have jurisdiction over it. They have to pass it to the judge. So your question is, is ICE arrest illegal just because you have an asylum pending? No. A pending asylum case does not always prevent immigration from arresting or placing someone in proceedings. I also found out this many years ago in a painful way. The fact that you have an asylum pending does not always mean or prevent immigration from placing you in proceedings, especially if immigration believes the person is removable or has enforcement concern. Let's say you have a criminal record and you have an asylum pending. Immigration is not going to say because you have asylum, they can't try to deport you. Or maybe you made an illegal re-entry after you have been deported, and then you now file asylum now. That asylum is not going to stop immigration from arresting you if they want. And as to the other part of your question, whether immigration has to decide the affirmative asylum first before issuing the notice to appear, I think that's what you're asking there. No. My answer will be no, not always. Once the NTA is issued, which is the notice to appear, for those who might be wondering what is an NTA here, once the notice to appear is issued and court proceedings have started, the asylum claim can be heard by the immigration judge instead of immigration. It goes to the immigration judge. So your focus now, if that has happened, should be confirm that the immigration court has your I-589 or file a new one before the judge. Yes, you can file or renew the asylum, the withholding and CAT before the judge. That will help you to preserve your original filing dates. And then you can get your lawyer to request bond if you are detained. And then you can have your counsel review whether ICE violated any procedure, which I don't think they did here. But your lawyer will know better because he will get all the facts. James, I have to be honest with you. This is serious. But it is not the end of your asylum case. I think the case has probably moved from immigration, that is USCIS, to immigration court. And in my own opinion, you actually have a better chance of winning your asylum before the judge than with immigration these days. Immigration is already predisposed to not granting you asylum anyway. But the judge will patiently listen to your story. He will listen to your documentation. And if you merit approval, typically a judge will grant you that. So don't panic yet. Okay? Your asylum case might just have been moved to the immigration court. Okay.